Hi, I'm James Minick with Minick Law. We concentrate our practice in criminal defense, personal injury, and family law. And today I'm going to talk about challenging an arrest based on a lack of probable cause to have made that arrest, and in particular focusing on making that challenge in a driving while impaired case. This is going to be more designed for attorneys or legal professionals to help kind of create or kind of conceptualize the attack to probable cause in a driving while impaired charge. A probable cause has been defined. There's a number of cases that define generally probable cause, but has been defined by our courts as a reasonable ground of suspicion supported by circumstances strong in themselves to warrant a cautious man in believing the accused to be guilty. That is a definition from State versus Teate, a 2006 case. And again, we're looking at circumstances strong in themselves, and also want to emphasize to the court that would warrant a cautious man in believing the accused to be guilty. So make sure that you emphasize those particular pieces of the standard. Probable cause is determined by looking at a totality of the circumstance. Every case is different on this front. It's all about the facts and circumstances of each particular case, which in some ways is good because we can argue this in many cases, since it's a look at each individual setting. And it's also somewhat harmful because some of the cases that I'm about to go over in just a moment that are actually helpful in terms of attacking probable cause have sometimes little bearing because of the fact that each judge should be really looking at each individual arrest in its individual circumstances, as opposed to kind of having much precedent from prior cases. We have had recently two great appeals decisions in terms of finding a lack of probable cause, and those two recent cases are State versus Sewell, which is an unpublished Court of Appeals opinion, and State versus Overocker. Overocker was 2014, Sewell was a 2015 case, so both recent decisions. Again, if you're going to argue Sewell to the court, you need to make sure that you're telling the judge, Your Honor, I'm using an unpublished decision, that this is not a published opinion. However, in a probable cause setting, again, really whether it's specifically the exact same circumstances or not, shouldn't really have a whole lot of bearing in the first case because of the fact that we're looking at the individual circumstances of every particular arrest. In Sewell, the court basically found that the defendant had red glassy eyes, a strong odor of alcohol emanating from the defendant's vehicle, did not specifically link that to the defendant. 6 of 6 clues on the horizontal gaze nystagmus test, so on what the state would argue is the most accurate of all field sobriety tests, or at least what they should be arguing is the most accurate, that there was 6 of 6 clues in the Sewell case, 2 positives on the Alka-Sensor, and also the defendant in Sewell initially denied drinking. He later admitted drinking, but initially denied. So you have kind of that falsification of information to the officer. So something that we routinely see in driving while impaired charges are these clues and indicators: red glassy eyes, smell of alcohol, 6 of 6 on the horizontal gaze. What was not evidenced in Sewell was bad driving. It was a checkpoint case. There was no slurred speech that was noticed by the officer. No trouble in retrieving license and registration, no clues on the walk and turn or on the one-leg stand, and that the defendant was generally steady on his feet. The defendant was also found by the officer to be polite and cooperative, but in many cases that is a finding made by the officer. So in balancing all of these things, the court found that the evidence of impairment did not outweigh the evidence of sobriety. Again, it's a facts and circumstances test. The standard is circumstances being strong in themselves to warrant a cautious man in believing the accused to be guilty. And how many times in a driving while impaired charge do we see that level of cautiousness exercised. It generally feels like if there's any clues of impairment that are seen by the officer, then we are immediately moving towards an arrest. So remind the court that in the Sewell case there was evidence of sobriety, but there was also a number of clues of impairment that were found. It wasn't just admission of drinking, smell of alcohol, and a positive on a PBT. There was red glassy eyes, initial dishonesty with the officer, and in most particularly 6 of 6 clues that were found on the horizontal gaze nystagmus test. The court found that that did not amount to probable cause given the showings of sobriety from the defendant. Overocker also has a number of kind of balancing going on, clues of impairment, clues of sobriety. The particular thing to note about Overocker is that an accident alone is not sufficient evidence of impairment, and that the courts have really held that for a long time, that an accident alone is not enough to show impairment. There has to be, if the state is going to argue that the accident is evidence of impairment, they have to show some connection between the circumstances of the accident and the fact that a person is impaired. And I think that's important because there seems to be a general tendency with the district attorneys and in the state's presentation of evidence, if there is an accident, to basically hammer that in terms of that being indicative of impairment. Use the Overocker decision to say, no, there has to be circumstances that relate the accident to evidence of impairment. Again, if you're attacking the probable cause, the first thing to arrest, the first thing you want to do is very clearly lay out the standard for the judge, even if the court is typically familiar with that, and then use these recent cases to really show, it's not a matter of finding minimal evidence of impairment, just enough to be able to make an arrest. You have to perform, Judge, a true balancing of the evidence of impairment versus the evidence of sobriety. Bring all of that evidence of sobriety in your case out. If there's not a slurred speech, if the defendant is not having problems answering questions of the officer and communicating with the officer, sharing intricate details of an accident or sharing information about insurance, isn't having problems communicating with the officer, is doing well on field sobriety tests, is not having problems with balancing or being able to maintain conversation with other people on scene, isn't having any problems walking around on scene. The circumstances surrounding the driving are very important. Speeding in particular, under the NHTSA clues indicative of impairment, the NHTSA driving clues indicative of impairment, speeding is not one of those clues. If your client is pulled over for speeding, then their driving, if that's the only reason that they were pulled over, is not a clue of impairment. So all of the driving that the officer has seen would be evidence of sobriety or evidence of a lack of impairment because there have been no clues seen evidencing impairment. So again, bring out all of those clues of sobriety and then express to the court, pointing to Sewell and Overocker, that there has to be a true balancing test performed, and that in conclusion, the evidence of sobriety outweighs the evidence of impairment, and therefore probable cause does not exist.